Paternity and Filiation. The filiation of children may be by nature or by adoption. Natural filiation may be legitimate or illegitimate. Article 136 of the Family Code. Status of children. Who are legitimate children? Children who have the legitimate status include A. Conceived or born during the valid marriage of the parents. B. Conceived through artificial insemination. C. Children of a subsequent marriage after the declaration of presumptive death, conceived prior to its termination. D. Conceived or born before the final judgment of annulment under Article 45 or absolute nullity under Article 36. E. Conceived or born under the subsequent marriage under Article 53. F. Legitimated children under Article 157, 177. And G. Adopted children. Rights of a legitimate child. A. Bring the surnames of the father and the mother. B. Receive support from parents, ascendants, and brothers and sisters in proper cases. C. Entitled to legitimate and other successional rights. And D. Claim legitimacy. What are the effects of succession when the status of the child is legitimate? Legitimate children are entitled to 1/2 of the estate of the parent divided amongst themselves. Article 888 of the Civil Code. Let's proceed to illegitimate children. Who are illegitimate children? They are conceived and born outside a valid marriage. What are the rights of illegitimate children? 1. Bring the surname of the mother. 2. Bring the surname of the father if filiation has been expressly or recognized by the father through 1. Record of birth. 2. Public document. Or 3. Handwritten instrument. Next, receive support. 4. Entitled to successional rights. And 5. Establish illegitimate filiation. What are the effects of succession on illegitimate children? Each illegitimate child is entitled to an amount of 1/2 the share of a legitimate child. Legitimated children. Who are legitimated children? They are conceived and born outside a valid marriage, provided that at the time of conception the parents were not disqualified to marry each other unless the impediment was minority of either or both of them. And 2. The parents subsequently enter into a valid marriage. So di sila married when gi-conceive and gianak ang bata. But eventually they got married. What are the rights of legitimated children? Same as legitimate children. What are the effects of succession? Same as the legitimate children. Adopted children. Who are adopted children? Those adopted through domestic or inter-country adoption under Articles or RA 8552 and RA 8043 respectively. What are the rights of adopted children? From the Domestic Adoption Act, 1. Same as legitimate children, and 2. Right to rescind adoption under specific cases. Ay, sila ra ang makarescind, ang parent or adoptive parent dili makarescind. What are the effects on succession when the child is adopted? From the Domestic Adoption Act, 1. Same as a legitimate child, but the adopted child cannot inherit by representation because relationship is only between the adopter and the adoptee. Sison versus CA. So, meaning, if ang i-adopt nimo is namatay, you cannot claim for any inheritance nga makuha sa ni-adopt nimo from his parents, sisters, or brothers. Kaya ang inyong relationship is between only two of you. Okay. And also, He may also inherit from biological parents if they left a will, and only when they left a will. Legitimate children. Article 164. Children conceived or born during the marriage of parents are legitimate. Children conceived as a result of artificial insemination of the wife with the sperm of the husband or that of a donor or both are likewise legitimate children of the husband and his wife, provided that both of them authorized or ratified such insemination in a written instrument executed and signed by them before the birth of the child. The instrument shall be recorded in the civil registry together with the birth certificate of the child. A legitimate child is one that is born in lawful wedlock or within a competent time afterwards. The time of birth is the criterion of legitimacy. Who are legitimate children? 1. Children conceived or born during the valid marriage of parents. 2. Children conceived through artificial insemination. 3. Children of a subsequent marriage conceived prior to its termination. This refers to those subsequent marriages which were terminated after the reappearance of the spouse presumed dead. Okay. 4. Children conceived or born before the judgment of annulment under Article 45 or absolute nullity under Article 36 has become final and executory. 5. Children conceived or born of the subsequent marriage. 6. Legitimated children. And 7. Adopted children. Adopted children are legitimate children. Natural or biological. A child conceived or born during a valid marriage is presumed to be or to belong to that marriage, regardless of the existence of extramarital relationship. Liao versus Liao, 2002. Artificial insemination under Article 164 of the Family Code is the impregnation of a female with the semen of a male without sexual intercourse. The child conceived through artificial insemination with the consent of both husband and wife is legitimate. The Family Code does not require a condition for the legitimacy of the child, the impotence of the husband. Even without the initial consent, the child can still be legitimated so long as the husband subsequently gives his consent before the child is born through artificial insemination. Requisites to be considered legitimate. 1. Artificial insemination made on wife. 2. The sperm comes from any of the following: A. Husband. B. Third person donor. Or 3. Husband and third person donor. 2. In case of a donor sperm, the husband and wife must authorize or ratify insemination in a written instrument. Written instruments shall be 1. Executed and signed by husband and wife before the birth of the child, and 2. Recorded in the civil registry together with the birth certificate of the child. Article 164 of the Family Code. Dual consent is required whether the semen used comes from the husband or a third person donor. Common children born before the annulment are legitimate and therefore entitled to support from each of the spouses. De Castro versus Acido de Castro, 2008. Proof of filiation. Proof of filiation is necessary. 1. Where the child is born after 300 days following the termination of the marriage, the child has no status, and whoever alleges legitimacy must prove it. 2. If the legitimacy of a child conceived or born in wedlock is impugned, and the plaintiff has presented evidence to prove any of the grounds provided in Article 166, the proof of filiation may be used as a defense. Legitimate children may establish their filiation in any of the following. Article 172. A. Primary evidence, and B. Secondary evidence. Primary evidence for voluntary recognition is 1. The record of birth appearing in the civil registry or a final judgment, and 2. An admission of his filiation by his parent in a public document or a private handwritten instrument and signed by said parent. Secondary evidence for involuntary recognition is 1. Proof of open and continuous possession of status as legitimate child, and 2. Any other means stated by the rules of court or special laws. Take note that only in the absence of primary evidence can secondary evidence be admitted. Action for claiming filiation for legitimate children. Article 173. 1. The child can bring the action during his or her lifetime. 2. If the child dies during minority or in a state of insanity, such action shall be transmitted to his heirs, who shall have a period of 5 years within which to institute the action. And 3. The action commenced by the child shall survive notwithstanding the death of either or both parents. Rights of legitimate children. Article 174. 3s. Support surname succession. 1. To bear the surnames of the father and the mother in conformity with the provisions of the Civil Code on surnames. 2. To receive support from their parents, their ascendants, and in proper cases, their brothers and sisters, in conformity with the provisions of the Code on support. And 2. To be entitled to legitimate and other successional rights granted to them by the Code. Future support shall be the subject of a compromise pursuant to Article 2035 of the Civil Code. The reason behind this prohibition is future support cannot be the subject of a compromise pursuant to Article 2035 of the Civil Code. The reason for this prohibition is because the right to support is founded upon the need of the recipient to maintain his existence, and thus the renunciation of such will be tantamount to allowing the suicide of the person or his conversion to a public burden, which is contrary to public policy. In the case of the Assis versus CA, 1999. Illegitimate children. Article 165 of the Family Code. Child or children conceived and born outside a valid marriage are illegitimate, unless otherwise provided in this code. Who are illegitimate children? Generally, those conceived and born outside of a valid marriage. Exceptions. A. Children of marriages void under Article 36 or psychological incapacity, meaning dili sila illegitimate but they are actually legitimate. 2. Under Article 53, subsequent marriages which did not comply with Article 52. So they are legitimate. Action for claiming illegitimate filiation. Illegitimate children may establish their illegitimate filiation in the same way and on the same evidence as legitimate children. 1. For actions based on primary evidence, the same period stated in Article 173 of the Family Code apply. Lifetime of the child and will not be extinguished by the death of either parent. So long as buhi pa ang child, bahalag patay ng parents, basta kay buhi ang child, he may file for illegitimate filiation. The same with legitimate filiation if primary evidence ang naaniya. For actions based on secondary evidence, action may only be brought during the lifetime of the alleged parents. So, if secondary evidence ang nani mo, you can only bring such action during the lifetime of the alleged parents. The same kind of evidence provided in Article 172 for establishing legitimate filiation may be used to prove the filiation of illegitimate children, and the action for this purpose must be brought within the same period and by the same parties as provided in Article 173. However, if the evidence to prove the filiation is secondary, the action must be brought within the lifetime of the alleged parent. Primary evidence. Baptismal certificates are given probative value only for births before 1930. Birth certificates must be signed by the parents and sworn for it to be admitted as evidence. Mendoza versus Milia, 1966. The signature of the father on the birth certificate is considered as an acknowledgement of paternity, and mere presentation of a duly authenticated copy of such a certificate will successfully establish filiation. Iseta versus Iseta, 2004. Unsigned birth certificates are not evidence of recognized filiation. Baluyot versus Baluyot, 1990. The due recognition of an illegitimate child in a record of birth, a will, a statement before a court of record, or any authentic writing is in itself a consummated act of acknowledgement of the child, and no further court action is required. De Jesus versus Estate of Decedent Juan Gamboa, Dizon, 2001. Secondary evidence. Rule 130, Section 40 is limited to objects commonly known as family possessions, reflective of a family's reputation or tradition regarding pedigree, like inscriptions on tombstones, monuments, or coffin plates. Hison versus CA, 1998. Su padre, or your father, ending in a letter, is only proof of paternal solicitude and not of actual paternity. Signature on a report card under the entry guardian, parent or guardian is likewise inconclusive of open admission. The heirs of Rodolfo Bañas versus heirs of Bibiano Bañas, 1985. The mere possession of a status as an illegitimate child does not make an illegitimate child recognized, but only a ground for bringing an action to compel judicial recognition by the assumed parent. Gono Javier versus CA, 1994. To prove open and continuous possession of the status of an illegitimate child, there must be evidence of the manifestation of the permanent intention of the supposed father to consider the child as his, by continuous and clear manifestations of parental affection and care, which cannot be attributed to pure charity. Perla versus Baring, 2012. Meanwhile, the lack of participation of the supposed father in the preparation of a baptismal certificate renders this document incompetent to prove paternity. Baptismal certificates are per se inadmissible in evidence as proof of filiation, and they cannot be admitted indirectly as circumstantial evidence to prove the same. By open and continuous possession of the status of a legitimate child is meant the enjoyment of the child of the position and privileges usually attached to the status of a legitimate child, like bearing the parental surname, treatment of the parents and family of the child as legitimate, constant attendance to the child's support and education, and giving the child the reputation of being a child of his parents. De Jesus versus Siquia, 1933. Other evidence. DNA evidence can be used as a proof of paternity. DNA evidence can still be used even after the death of the parent. Marriage certificates cannot be used as proof of filiation. Lim versus CA, 1975. There are 4 significant procedural aspects of a traditional paternity action that parties have to face. 1. A prima facie case. 2. Affirmative defenses. 3. Presumption of legitimacy. And 4. Physical resemblance between the putative father and child. A prima facie case exists if a woman declares, supported by corroborative proof, that she had sexual relations with the putative father. At this point, the burden of evidence shifts to the putative father. Further, the 2 affirmative defenses available to the putative father are: 1. Incapable of sexual relations with the mother due to either physical absence or impotency, or 2. That the mother had sexual relations with other men at the time of conception. Case of Gotardo versus Bowling, 2012. Rights of illegitimate children. Article 176 of the Family Code. Illegitimate children shall use the surname and shall be under parental authority of their mother and shall be entitled to support in conformity with this code. However, illegitimate children may use the surname of their father if their filiation has been expressly recognized by the father through the record of birth appearing in the civil register, or when an admission in a public document or private handwritten instrument is made by the father, provided the father has the right to institute an action before the regular courts to prove non-filiation during his lifetime. The legitim of each illegitimate child shall consist of one half of the legitim of a legitimate child, as amended by RA 9255 in 2004. Illegitimate children shall use a surname and shall be under the parental authority of their mother, and shall be entitled to support in conformity with this code. The legitim of each illegitimate child shall consist of one half of the legitim of the legitimate child.